Well, Henshaw here again for the Constitutional Crisis Channel. Today's subject, and I'll try to keep it brief, judges and lawyers, are they guilty of treason? I answer yes, they are, and it's not me saying it here. It's the Supreme Court of the United States in the case of Cohens, C-O-H-E-N-S versus Virginia, 19 U.S. 264, the best case that was ever decided by the court, in my opinion, written by Chief Justice John Marshall, that infallible icon of Harvard and Yale. The guy was never wrong, was he? And it says right in there that the court has a duty to take all the cases, that come within its jurisdiction, but it also has the obligation to refuse jurisdiction where it's not given. The one or the other would be treason to the Constitution. I agree with him. I further note that Article 6, Section 2 of the Constitution of the United States says, and I quote, "This Constitution and the laws enacted in pursuance thereof shall be the supreme law of the land." The obvious question here is, who gets to define in pursuance thereof? The Supreme Court has sanctimoniously declared that they have the power to say what the law is. One of the few cases that you probably ever heard of in the mandatory public schools, Marbury versus Madison, 1 Cranch 137, which you can also Google at 5 U.S. 137. Problem from where I come from is that in the last 80 years, if not longer than that, they have very seldom exercised the right to tell the American people what the law is. Because, in my view, if they do that, they're going to have to admit to a lot of treason that's been carried out by not only members of the court, but members of Congress and attorneys as well. Of further note that judges and attorneys, quote-unquote, in both cases, are all required to be members of the quote-unquote State Bar Association. Now, if that's true, and if I have established, and I have, that California is not a state admitted into this union, Article 4, Section 3 of the Constitution of the United States, then as territorial government officers, these attorneys and judges must be appointed by the President, pursuant to the Appointments Clause, Article 2, Section 2, Clause 2, and none of them have been. The only other possibility is, if they're to be elected, the elections would have to be provided for by Congress in the given territory. And yes, they know how to do that. You can check it out for yourself. It's called the Act to create the government of the Territory of Oregon at 9 Statutes at Large 323 et sequel, enacted August 14th, 1848. And you can go to the Statutes at Large, on your computer, and you can go right to that. You'll see that it's there. Congress knows how to do this. But the problem is that I can't find any laws that have provided for any elections in the territory of California. So these attorneys and judges are neither elected or appointed. And it makes it real difficult for me to find any factual foundation or legal basis for them to have any power to do anything. And I think, by the way, referring to an earlier case I've discussed with Jerome Daley, the Turner versus American Bar, I think that's the basis that they got all the judges disqualified and forced Chief Justice Earl Warren to appoint a special master for the case. I believe that's the type of argument they were making, but I've never been able to find their documents they filed on it. I would love to see them. But that's what's going on here. So, in effect, if we're sitting here in a territory, none of these so-called courts, and all of them fraudulently pretend to be state judicial courts of common law general jurisdiction, when what they really are federal legislative tribunals exercising federal, regional, martial law rule. None of them have jurisdiction in any of these cases, and they're all liable. They don't have any quote-unquote judicial immunity to claim. How could they if they're acting in the legislative department of government? And one of the best cases you're going to see on this subject, and I encourage you to take a long look at it, Ex parte Loudon P. Milligan, Lambdin P. Milligan, Millgan, that's 71 U.S. 2, decided right contiguous with the war between the states And Milligan had been arrested and convicted by a military tribunal, had a rope around his neck, and the attorney said, "Not so fast," and filed this writ with the Supreme Court of the United States. And they sustained it, and Milligan was released. They had to, because the military commission didn't have any jurisdiction, especially in the state of Indiana, in which there had been no fighting during the war between the states. It may have been questionable in the southern states as well, but that's not the case we have to deal with here. But you get real familiar with that case, they're going to have a hell of a hard time beating you too, because that's what they're doing today with no known declared state of rebellion or invasion, which is required by Article 1, Section 9, Clause 2. Note here, by the way, you rarely, if ever, heard me refer to the Bill of Rights. Amendments 1 to 8, you don't need them. Horse hockey. I do use the 9th and 10th articles of amendment, because those are the ones that secure rights to private individuals like us and to the states themselves. Those are relevant. The first 8, forget about it. You don't need them. Anybody that advocates those, run, don't walk to the nearest exit. And bottom line is, they ain't going to work except in the case where the government thinks it has to make it look good. But getting back to the courtroom scene, quote-unquote courtroom, this is where we get the bastards to rule in our favor, because they have an oath of office to preserve, protect, and defend this Constitution, and presumably the laws enacted in pursuance thereof. If they're not doing it, then there's not only no excuse for it, that's a plain act of treason, and they don't have any immunity whatsoever from being removed from office and having their houses, their homes, their retirements taken away from them, and maybe spending quite a long time in one of their jails to boot. I would love to see that happen, although with me, I would personally prefer 20,000 volts, but that's over the course of 4 decades and the frustration I've suffered. You can understand that one. We'll be talking a lot more about this later. Thank you.